Hello, welcome to the domestic violence update that I will be presenting to you for the next hour. I'm going to start by sharing my screen so you can see the PowerPoint that I have for you all. And I'll introduce myself. My name is Lauren Zorfas. I am a retired court commissioner. I served on the San Mateo court bench, and I oversaw many different types of cases, including the Domestic Violence Protection Act cases, or what we call the DVPA. I did retire from the court. However, I can't seem to stop working, so I went back to the firm that I founded, ADZ Law. We're located in San Mateo. And right now, my family law practice is restricted only to doing private judging, mediation, and parent coordination, arbitration, basically any neutral work within the realm of family law. So I'm going to get into the meat of our presentation today. And what I'm going to be talking about today, as I said, is updating you all on domestic violence. And I'm going to be doing it in the next hour through case law that has come out. There's been a plethora of cases that have come out at the end of 2023 and this year, 2024, as compared to the same time period last year when we didn't have much new case law, maybe because we had that pandemic thing. But the court really took a deep dive into what is domestic violence when we're talking about non-physical violence. So there's actually 5 cases that came out within the time period we're talking about that explore that. And so I'm going to explore that with you because obviously this guides our practice. So the first case that we're going to talk about is Hatley versus Southard. And this is a case that came out the end of last year. And Hatley, the parties were married. She files for a domestic violence restraining order after the parties had separated. And what she alleges is that there's a pattern of control and isolation by husband, that he limits her access to money, communication, and transportation. And she also requests spousal support in her petition. And she alleges in her petition, and I quote, that there were numerous incidents of physical, financial, verbal, and emotional abuse. She filed in 2022. So she alleges one allegation of actual physical harm that she says took place in 2017 or 18. She can't really remember, but husband tried to smother her with a pillow. She also has an allegation that he threatened to physically harm her, and she couldn't really remember when that was. But she also alleges that he has made threats of self-harm in order to manipulate her, and he's done this for over a decade. So when she gets into the specifics of how he has quote unquote abused her, she talks about the financial abuse. He wouldn't allow her to work, and they had a setup where she had to ask him if she could spend any money. She would have to make a request to him. He would approve it or not. And if it was approved, transfer that money into an account she had access to. But other than that, she had no access to any marital funds. He also restricted her transportation. She wound up buying her own car after separation. And by that time, husband had moved to Kentucky, but he took her car that he knew she had bought post-separation. He took that with him. And part of why this was abusive, aside from the fact that she couldn't go anywhere, there was another layer to this in that she had a child from a previous relationship, and her only way to see that child was with the car. And when he took the car, he knew he would be depriving her of her ability to see her daughter. She also alleged that he isolated her. He refused to pay for her cell phone. And then finally, when he did, he actually used that to track her after they separated. She also made sort of a vague allegation of sexual abuse, where she didn't describe anything in great detail. But she did talk about the sexually degrading, or she mentioned in her moving papers, the sexually degrading comments that he made after he learned that she was dating, again, after separation. So based on her allegations as set forth in her moving papers, the court denied the temporary restraining order, but it did set a hearing, as it has to. And what the court stated is the facts as stated in the Form DV 100 do not show a reasonable proof of a past act or acts of abuse. And husband responds and says that wife filed the restraining order because he filed for divorce. What's very interesting is she actually filed the DVRO before he filed his divorce petition. And he said that really no restraining order is necessary because by now he had moved to Kentucky and wife was in California. He also denied the allegations of abuse. He did admit to the text messages, and these were messages where he made the sexually degrading comments, and he just says he's embarrassed by his comments. At the hearing, wife represented herself. Husband did have an attorney. The wife testified to the financial control, that she didn't have access to funds, the harassing messages and the suicide threats, and the fact that he was depriving her of access to her vehicle. And the judge indicates that her testimony is really not abuse under the DVPA. And he asks her, and I have a lot of quotes from a lot of these opinions because it's so important that you're hearing what the judge says, because it's very telling about how the trial court feels and how the appellate court has instructed the trial courts in its understanding and what the legal definition really is of abuse under the DVPA. So the judge interrupts her and says, "What abuse? Tell me what you're complaining of. I mean, I know that he took your car and the car meant a lot to you, but what else? He called you names?" So wife then expands her testimony and talks about the abusive conduct, citing an incident where post-separation husband had come to her home and stayed there for over 2 hours despite her asking him to leave. Trial judge interrupts her again and says, "Let's try to focus on what Mr. Souther did to you that you feel was either violent or abusive. I don't want to hear all the problems of your marriage and your relationship." Just have to make my side comment. Reducing domestic violence to a problem is stunning to me. But after further testimony by the wife, the trial judge finally asks, "Has Mr. Southard ever hit you?" And this is where we really understand where the trial court is coming from. The trial court has decided that abuse is physical abuse. And she tried to talk about the incident where there was sexual abuse. But remember, I said in her pleadings, she didn't plead that with any particularity. In other words, she didn't add any details to that. And because she didn't, the judge said the specifics were not in your pleadings, so that can't be introduced here. And that very issue, we're going to see again in a later case, Bailey v. Murray, where the court says, no, you can talk about things even if they weren't even mentioned at all in your pleadings. So the court, not surprisingly from what we've heard so far, denied the petition. And he says it does not fall within the statutory definition of domestic violence or abuse. And the court also denied the spousal support request. So on appeal, the District Court of Appeals goes through the statutory definition of abuse, and they really focus on the disturbing of the peace portion that's set forth in Family Code section 6320A. Actually, it's in 6320 in total, and how that and coercive control are defined, and examples of coercive control are set forth in 6320C. And the appellate court says the statute should be broadly construed in order to accomplish its purpose of preventing acts of domestic violence. And this is citing Marriage of FM and MM, a 2021 case. And the court says, because the court has two standards, one is a de novo review or an abuse of discretion. And the court says this isn't even abuse of discretion, it's a misapplication of the law. So again, these snippets from the opinion, I think, are so helpful in really painting a picture of how non-physical harm is defined in our statutes and through case law. And the court says these attempts at financial control, if established, would constitute incidents of, and here we quote both the statute, which was quoted in Rodriguez-Menjivar, depriving the other party of basic necessities and controlling, regulating, or monitoring the other party's finances, economic resources, or access to services, which are by definition abuse under the DVPA. Treating these incidents as just evidence of marital problems was error. So again, the court is looking to the statute where it says in black and white, controlling the finances, access to economic resources and services, that is per se a violation of the DVPA. It is defined. Exercising control over a spouse by regulating her movements and communications, because he took her cell phone, is defined as abuse under the DVPA, as is isolating her from supportive relationships, again, citing back to the code. And the court goes on to say about Southard that when he learned she was dating someone else, he showered her with abusive text messages, which she filed. She attached those to her pleadings. These repeated messages were sexually degrading and plainly had the capacity to shame Hatley and disturb her peace of mind. So the Court of Appeals remands the case to the trial court to make factual findings and credibility findings, and said on remand that Hatley should be allowed to testify as to particular acts of sexual abuse. She should have been allowed to testify to those acts. And when you generally allege something, you're already putting the other side on notice, because part of the issue with addressing things in court that aren't in your pleadings is a due process issue. So, for example, a respondent can say, I had no idea that I was going to be faced with that allegation, and therefore I'm not prepared. I didn't have time to prepare a response. But what we're seeing, and again, we'll see more of this in Bailey v. Murray, is you're on notice that domestic violence allegations have been made against you. And so you have that notice. And so the court is, I don't want to say lowering the bar, but the idea that there's a due process violation when you've already been put on notice that there are domestic violence allegations against you is probably not going to fly. The court also said that the denial of the spousal support was error, and even if the restraining order is denied, the court must address spousal support if it's pled properly. And what the court is saying is both parties filed income and expense declarations. So oftentimes, there's variety of orders you can ask for in a restraining order request. You can ask for custody, visitation, child support, spousal support, and providing you ask for those correctly and provide the supporting pleadings, which in this case, if you're asking for financial support, you must file an income and expense declaration. Well, Hatley did. And ironically, so did Southard. So the court had everything it needed to make a spousal support determination. And this is not in the opinion, but as I look at this case, I wonder, is denying spousal support another way to continue abuse? So there's already been financial control, and leaving a victim of domestic violence without financial support, although supporting somebody post filing is not necessarily an act of domestic violence, it is, when the court denies it, a way, in my opinion, the court can continue the abuse. So the next case that we look at in terms of, again, what constitutes abuse under the Domestic Violence Prevention Act is a case, I think it's Jan F. and Natalie F. And in that case, the parties were not married, and they were living separately because there was already an order for custody and visitation because a UPA action had already been filed. Mother then filed for a TRO because father, Jan, was making, as she alleges, false reports to the police to conduct welfare checks on the children while the kids were in her care. What had happened is, in the UPA, the court issued a temporary supervised visitation order. And the court said, it made a statement in its order, and it's not a finding yet, but the court nonetheless puts this in the order. Evidence has been presented in support of a request that the contact of father with the children should be supervised based on allegations of abduction of the children, domestic violence, and alcohol abuse. The court noted that those allegations were disputed and reserved findings on those issues to a hearing. And the court also ordered communication through Our Family Wizard, or OFW. So 1 year later, after the supervised visitation order is in effect, mother files for the restraining order. And what had happened is, since the first custody order, father's visits had then become modified to video call visits. And I'm going to talk about video call visits in a little bit. But the video call visits were to be continued pending a completion of one co-parenting session, and mother was living in a domestic violence shelter. And I read this case, and the appellate court doesn't say anything about it, but what ran through my mind is they're doing co-parent counseling where there have been allegations of abuse, a mother staying in a domestic violence shelter. The court was aware of this. I really question the co-parenting session, but I just want to bring that out. So mother produced evidence that within a 3-week period, father used the police, as she says, to harass her, find her address, because remember, she's staying in a domestic violence shelter, and by asking them to perform unnecessary and intrusive welfare checks. So we're seeing, okay, she's alleging disturbing the peace via the police. She also declared that father sent over 100 emails and 37 OFW messages that were accusatory, argumentative, and abusive towards her and her attorney. You can imagine who wrote the declaration. The court denied the temporary and set a hearing, and it doesn't say why the court denied the temporary in the appellate opinion, but one can imagine, again, the court is not seeing physical abuse, and the court is seeing that there is this harassment, but through a third party. So at the hearing, the judge asks, as oftentimes we do, is everything true and correct in your pleadings? And mother's attorney says, yes, it is. And the court says that there is insufficient evidence to support a restraining order. Now, the court notes that the OFW messages were inappropriate and were not helpful to father's custody and visitation position. Further, there were consequences, including possible criminal consequences, of involving police departments or law enforcement when there isn't a legitimate reason to do that, if that's what's going on. And then the court says, I'm not saying it's never something that could be used as a form of harassment. But all that being said, I'm not inclined to restrain any of this conduct under the DVPA. So the judge is basically saying, this is probably harassment, but I'm giving you a warning. And we have seen in previous cases, if it looks like harassment, if it smells like harassment, it's harassment and it must be enjoined, and a restraining order would have to issue. And the judge also explains, by the way, his position for denying the restraining order is that he was fearful to take away father's right to call to check on his children if there was a legitimate reason to do so in the future. So at this point, when the court denies the restraining order, mother asks the court to modify the visitation order to suspend the video calls or have them professionally monitored. And in denying this, the court says, those activities, while I understand they're annoying, but they're not domestic violence. So we're splitting hairs between what's annoying and possibly harassment, but it's not domestic violence. And I also want to point out that in the facts of this case, what happens is there were some missed video calls for visitation. Some were at the fault of the parties, of both parties. Some were really not the fault of the parties. They tried to reschedule them. But every single time, mother had a legitimate reason to reschedule or not have the video call, this is when father would call the police. So there was a retaliatory nature to it. The other thing I want to point out at this point in this case, mother is staying at a domestic violence shelter and there are video calls. I understand that this case, I believe at the time it was at the trial court, was 2022. So we're pretty post-pandemic. Video calls and video visitation have a place, but you really need to be thoughtful about that place. They're not monitored. So we have the one issue of what is happening during that video call, and are we making the victim of domestic violence the monitor because he or she is the only one around? And if this person is in a shelter, is it smart to have a video call where the person she's seeking protection from can see where she is, or possibly see where she is? So I just throw that out there for something to think about. And then the trial court addresses the father. And I think this is really where the appellate court had an issue, and says, if you have something to say, I'm happy to listen to it. Although I just ruled in your favor and there's no obligation that you say a word. So if you want to be heard, you can certainly be heard, understanding that you probably don't want to talk to me out of ruling in your favor, yes? And father, as if he doesn't hear a word of that, starts to explain the context of the calls, and the court says, no, I don't need to hear about that. So the court is basically telling him, stop, we're done. So the holding, once the case gets to the appellate court, is this: the frequency of father's calls to police in a short period of time, that they were often made mere minutes after a purported missed call, and that father contacted the police for a welfare check rather than contact mother through OFW first, indicates that father seized upon opportunities to harass mother by making baseless claims to the Santa Monica Police Department that she had left California with the children and fomenting unnecessary welfare checks. So now we're seeing another way that harassment, disturbing the peace, can be defined: excessive welfare checks. So the next case, again, is a case where we're looking at the definition of domestic violence when it doesn't involve physical violence. And this is Paris J. versus Christopher U. So Paris and Christopher were married, and after divorce is filed, Paris files for a restraining order against Christopher, and also a request for order asking the court to compel husband to cancel a $4 million life insurance policy on her life or change the beneficiary to the charity of her choice. Some interesting facts in the case: when the parties met, wife was 27, husband was 48. So they have a 21-year age difference. Wife goes to grad school, and then shortly after marriage, she moves to Charlotte, North Carolina, because she gets an internship there. Husband rents an apartment for her, and the apartment is solely in his name, and he pays for it. And no surprise here, just given their stations, their ages, he has substantially more money than she does. So disagreements arise in their marriage. He is accusing wife of cheating on him. He insults her, berates her, and he says, "I'm kicking you out of the home in California, and I'm going to burn your things." This is while she's in North Carolina. She flies back to California, and with the civil standby and husband not home, retrieves her belongings and goes back to North Carolina. And it appears from the way that the opinion is elicits the fact that he didn't know she was coming. So less than a week later, he flies to North Carolina, and he gets into her apartment with a spare set of keys that he gets from the landlord because the apartment's in his name. There's conflicting testimony about what happened that night, but it seems they slept in separate bedrooms in the apartment. Also, wife alleges that he would not let her out of the apartment, and she is able to, quote unquote, escape the next morning. She calls a friend who did have a spare set of keys, and they get into the apartment and get her out. After this, wife says, "Let's have an amicable divorce." Ha ha ha. And husband again goes with the accusations of cheating and calls her countless lewd and demeaning names. And that's what the court says. He also threatens her and her family. So she files for the restraining order, asking the court to terminate the policy or change the beneficiary. And she asks the court to find that the life insurance policy is a separate and further act of domestic violence against her. So now we've gone from police checks, now life insurance policies. The appellate court agrees with the trial court that husband's actions of using his money, power, and emotional abuse to control wife did constitute abuse under the DVPA. It disturbed her peace. But husband says in his appeal that the 2020 amendments to 6320, which is the ones that added disturbing the peace and coercive control, is subject to a reasonable person standard. So would a reasonable person really have their peace disturbed or be coercively controlled based on his actions, which he, of course, says a reasonable person would not. But the Court of Appeals points out that the legislature specifically states a reasonable person standard applies as it is explicit in the statute in 6203. 6203A3 is the definition of abuse, and that is to place a person in reasonable apprehension of imminent serious bodily injury. But in 6320, there is no such reasonable standard. The only time 6320 mentions reasonable is when it talks about coercive control and disturbing the peace. The statute says the conduct includes, but is not limited to, coercive control, which is a pattern of behavior that in purpose or effect unreasonably interferes with a person's free will and personal liberty. Examples of coercive control include, but are not limited to, unreasonably engaging in any of the following. So it is not a reasonable person standard by any way, shape, or form coming from the perspective of the victim. The relevant inquiry is simply whether the person against whom the DVRO is sought engaged in conduct that, based on the totality of the circumstances, destroyed the mental or emotional calm of the other person. So then the husband says, well, the facts don't support that my conduct really rose to the level of abuse. His abusive text messages reflected a heated and emotional unwinding of the parties. They had a high conflict relationship. And he denies using his greater wealth to isolate or control wife. And I'm not sure how he reasoned around the fact that he did everything in his name, including her apartment. He also sent letters to her employer, basically just degrading her. And he said, no, that's not really a pattern of harassment, and that wouldn't have disturbed her peace of mind. And the appellate court says no, and no, and no. They say that husband did manipulate wife to becoming financially dependent on him. And there's a long discussion and the facts about how the husband was a gambler and had gambling debts, and wife actually had some money of her own. She had some tort recovery, and he got her to pay off his debts and then loaned him more money, such that she had no money left, and she was completely then dependent on him financially. And whenever she would ask him about the debts that he was accruing to her, he would just berate her. And there was one time where he basically induced her to drink too much and then took pictures of her getting sick, forced her to sleep on the floor, went into the room after she crawled on the couch and said, no, you have to sleep on the floor because you're a horrible drunk, and other horrible names. And then he took a picture of her and blackmailed her with that picture. And there were just many more examples of coercive control by means of degradation. So clearly his conduct rose to the level of coercive control, disturbing the peace. But the life insurance policy is very interesting. And this is a Los Angeles case. Most of you probably know Mark Uhas. He was the judge on the case, who is so methodical and so thorough. And in making his order, he first went through, the court has the authority to make injunctive orders and make orders that enjoin conduct that disturbs the peace of the other party. So after going through, here's why and how I can make these orders and the authority that I have to make these orders, he gives his reasons. So given husband's emotional abuse of wife during their relationship, having a $4 million policy on her life is abuse because it disturbed her peace. And the other factual piece that I haven't mentioned yet is she had to sign off on the policy, but when she did, he said it's a $1 million policy, just sign it, just sign it. And it was, DocuSign. And she said she didn't read it, she didn't realize, and she was shocked to find out that it was a $4 million policy. And again, he's a gambler. She knows this, she's had to pay his debts. And this is the first case to make this kind of a finding that a life insurance policy, and a big life insurance policy, could be disturbing of the peace. But it's the unique set of facts in this case that support that finding. And this is really, I think, the point of all of these cases where the court is really doing a deep dive into what is disturbing the peace, what is harassment, what is coercive control. You have to look at the totality of the circumstances. You cannot look at one act in isolation. And that's really where all of these cases are taking us. And I think this quote from the court says it all. We conclude that the trial court's order fell within the bounds of its broad authority under the DVPA to issue a panoply of remedial orders, citing Rivera and Hilliard. It is virtually impossible for a statute to anticipate every circumstance or need of the persons whom it may be intended to protect. Therefore, courts must be entrusted with authority to issue necessary orders suited to individual circumstances with adequate assurances that both sides of the dispute will have an opportunity to be heard before the court. And that's citing Nat Carney, which is the grandparent of most of our harassment and disturbing the peace cases. So the next case we look at is Vinson v. Kinsey. And in this case, again, what is domestic violence? And this case is a little bit shocking. So in the facts, Vinson applies for a restraining order against her ex-boyfriend, father of their two children. She files April 25th, 2022. And that's an important date because she says the most recent incident of physical abuse occurred in March of 2022, so a month prior. It actually is about 3 weeks. But at that time, he threatened to beat her face in and that he would kill her. There was also an incident in June of 2020 where he took her phone and punched her in the face and pushed her to the floor, leaving bruises. And she describes verbal abuse, threats to harm or kill her since January of 2010. And physical violence could result in bruises, but she couldn't remember the dates. She also submitted declarations from her mother, relatives, and friends who had witnessed the abuse and or had seen the aftermath. There was written testimony about holes being punched in the walls and those who had seen the bruises on Vincent. She also attached graphic texts from Kinsey where he says he'll kill her or beat her. At the hearing, she testified to the March 2022 incident where she picked him up in her car. And the court asked why, if he had threatened her numerous times, she would even go around with him and be alone in a car with him. And wife explains, he plays on my sympathy and he'll start crying. And I have a soft heart. I mean, and we do have children together. I mean, that's my stupidity. So what had happened here is Kinsey would share his food stamps with the family, but he didn't have a car. So he would make Vincent come get him so that she could get food for her kids. And the judge is asking her, why would you do that? So Kinsey then testifies that he was going through personal issues at the time of the threats, but he denies threatening to kill her, despite the fact that it says so in the text attached to her pleading. But he says, I specifically told her, I said, this is the type of stuff that will make me react this way, but I'm not directly telling you that I'm going to do this to you. Fascinating logic. And when the court asked Vincent to respond, she said he's lying and says, look at the texts that I attached to my application. So the court in its ruling says this, and I think it's really important. I hate to keep boring you with reading things from the cases, but this is really important language. The court doesn't understand why there was a delay in requesting the restraining order. This delay is 3 weeks. But perhaps it's because, despite the fact that Ms. Vincent repeats that she's been repeatedly threatened by Mr. Kinsey, she repeatedly goes back and has contact with Mr. Kinsey. So it's clear to the court that she's not particularly concerned about his comment that he will kill her. I don't know if that's a colloquialism. I don't know if that's just a phrase, but it has no meaning. So she's asking the court to interpret the meaning of that as being an attempt to engage in a violent act or threat of violence, but at the same time, she doesn't act like it's a threat of violence, and the court denies the restraining order. And in its opinion, the court looks to, it goes beyond statutes and cases and looks at treatises that are written about how a victim, how a survivor of domestic violence acts and why it's difficult to leave. Why do they stay? Why are they with their abuser? And why that is not a reason not to grant a restraining order. So obviously the court says, yes, threats are disturbing the peace, and that's straight up under 6320. And the court then goes on to say, the court's conclusion that Kinsey's threat to kill Vincent has no meaning, and Vincent doesn't act like it's a threat of violence, effectively imposed on Vincent a singular vision of how an abused woman should act. But all women exposed to violence and abuse in their intimate relationships do not respond similarly, contradicting the mistaken assumption that there exists a singular battered woman profile. Like other trauma victims, battered women differ in the type and severity of their psychological reactions to violence and abuse, as well as in their strategies for responding to violence and abuse. And the court could consider the timing of the filing of the restraining order from the date of the last incident as part of the totality of the circumstances. So again, we're going back to the totality of the circumstances. And the court seriously ignored the overall history of abuse. And I'm running lower on time, so I'm not going to read all of the just nuggets that the court gets from the literature that is out there, and really cites them very well in this case. So the next case I'm going to talk about is, again, what is abuse? And this case came up under the construct of a renewal. So the parties were unmarried parents of 2 children. Mothers granted a 2-year restraining order based on stalking, and then she sought to renew the restraining order. In the original restraining order, the court made custody and visitation orders, including using talking parents for communication, visiting only the older child 2 Sundays a month, and FaceTime calls with kids every Tuesday and Thursday. And I've already talked about the idea of FaceTime video calls when you're asking the person who is a victim of domestic violence essentially to be the monitor of those calls. It's really not the best. I'll just say that. So mother seeks to renew the restraining order because there was unwanted contact during the period of the restraining order. It was reduced, but it wasn't eliminated. So she gives examples of this. Several of the FaceTime calls were made outside the court-ordered times. Father tried to pass messages to mother through a family member rather than using talking parents. He still had mail coming to her home. Her uncle ran into him at the grocery store that she shops at, She had a video of what she believed to be father's car driving up her street, and father used mother's Apple account to purchase video games. In her renewal, she adds a new fact that wasn't introduced for the original restraining order. And this is important that's why I'm mentioning this. She says that the police have been called repeatedly for him manhandling her in public and in their home. At the hearing, father denies the allegations. And the court says, well, the FaceTime calls that he made were not intentional because he says, I accidentally called. And he had not established a pattern of driving past her home, and that her fear, while genuine, was not reasonable. So we're going back to this idea of a reasonable person standard. There isn't one. So the appellate court says Ritchie v. Conrad is the controlling case on renewals, and the court must renew if the person has a reasonable apprehension. Not are they a reasonable person? Does this person have a reasonable apprehension of future abuse, or whether a reasonable person in that person's circumstances would fear the repetition of the abuse if the order expired? So there's a three-pronged test from Ritchie. The court first has to consider the factual predicate for the original restraining order. Court must then consider any change in circumstances that occurred after the DVRO is issued, and then whether and how much the restraining order burdens the restrained party. And again, the court there's no requirement that the court find that there have been violations of the restraining order. And what it really comes down to is whether the apprehension by that petitioner is reasonable. The fears appear to be real, the trial court says. The question is whether they are, in fact, reasonable and genuine. So the court says they're genuine, but they're not reasonable. And the instances that she cites may be cause for alarm, but are not necessarily reasonably grounded. So again, if it looks like TV, if it smells like TV, if it's cause for alarm, it's DV. And again, the trial court says, well, there was no physical harm. And that, sure, the original restraining order was based on stalking, but what's been happening now is really coincidental. It's not a reasonable basis to continue the restraining order. And the Court of Appeals disagrees and says the restraining order can be renewed based on the original facts, even if those facts don't include physical abuse. And there were intentional violations of the restraining order. The initial restraining order is based on stalking. And again, I'm going to read the quote to you because it's important, where the court is making a distinction between types of domestic violence. Here, the court addresses stalking. The law does not permit courts to make a distinction between physical and non-physical abuse when issuing restraining orders. Nor is there any indication that courts should make such a distinction when deciding whether to renew them, and with good reason. Stalking is strongly associated with physical violence. Men who stalk their partners after a breakup are 4 times more likely to assault them. But stalking and other controlling behaviors are more than just useful predictors of future physical harm. They cause significant psychological damage on their own. So again, the court is saying, I'm not relying just on the statute, just on case law. There is information that is published out there that informs us on how we need to interpret our statutes. And again, the court looks to what distinguishes stalking from another type of abuse. And if the original order could be issued on a basis of reasonable fear of non-physical abuse, it can be renewed on the same basis. So the court runs through, again, the Ritchie factors Is there ongoing abuse? The court doesn't require a showing of further abuse since the original order, but stalking is unique. And then again, we have a cite to the literature and the published writings that we have on what is so unique about stalking. So the next case that we have is about firearms restrictions. And this is an interesting case because it involves a mother and a son. And they had a very rough relationship. And finally, the son moves out of the mother's house. It's not in the opinion, but based on the facts, I have to assume that the child is not a child, that he's an adult. But mom continues to have unwanted communication with him. She shows up at his house uninvited and unannounced, says derogatory things to him, nearly ran him over with her car, and discusses her newly developed interest in firearms in her unwanted communications with him. And the trial court grants the restraining order with the firearm restrictions, and mother appeals. And she appeals based on two prongs. One is that there was not substantial evidence to support the restraining order finding, but the court doesn't publish on that part of the opinion. So I'm not going to talk about that because it's not reliable authority. But it does publish the piece about firearms and does an interesting analysis of whether or not owning a firearm threatens the peace, disturbs the peace. Is that in and of itself an act of abuse? So part of what happened in this case is mother son didn't live very far from mother, and she would drive by all the time. Son was living with his girlfriend, and they hid in the bushes because she wouldn't stop tracking them. And that was when she says she was slowing down to talk to them. They say she tried to run us over. Um, all of the testimony that son gave, and I believe the girlfriend also testified at the hearing, show that mom had just relentlessly tried to harass and disturb the peace of her son, and his girlfriend would leave packages on his doorstep, things from his childhood, sent him messages saying, "You're pathetic, you're disgusting, I hate you." And again, these indications that she's very excited about being a firearms and has joined a club called A Girl and a Gun. And once she sent that, that's when he filed for this restraining order. So mother alleges that the firearm restriction violates her constitutional rights, and she should be allowed firearms for self-protection. And that 6389, which is the family code section that says you can't own firearms if you are the subject of a restraining order, that violates the 14th Amendment, which is the Equal Protection Clause, because it holds differently those who have employment where they're required to have a gun and those who want to have a gun for self-protection, because there is an exception where the court can say you may own a firearm for purposes of your employment. So, for example, if you're a law enforcement officer, there can be limits where you can actually have a firearm in your possession so that you can continue to work. So mother equates this with, well, if you allow someone to have it for employment, I should be allowed to have it for self-protection. And she also makes a Second Amendment argument that, we have a right to bear arms. And the court quickly dispenses with the Second Amendment argument because we have case after case that upholds the fact that a felon can't have a firearm, so the restrictions on firearms is not endless. But as to the 14th Amendment, the court says you're not similarly situated to somebody who needs a firearm for employment. And that exception is also very narrow. And the court looks to the rational basis test, which, when we're looking at constitutional issues, is there a rational basis for the legislature to enact what it has enacted? And here, the court says, yes, there's a rational basis to protect the public. And the court also says firearms and domestic strife are a potentially deadly combination nationwide. And we see this over and over again, don't we? The interesting thing is, while Zachary v. Terry was being decided, the United States Supreme Court had before it a case called U.S. v. Rahimi, which I'm going to talk about next. And there's U.S. v. Rahimi is basically the same challenge, the Second Amendment challenge, on a federal level, on a constitutional level, as to whether or not any state can restrict somebody's rights to bear arms because they're the subject of a restraining order, because there is a federal statute regarding the inability of somebody who is the subject of a restraining order to own or possess firearms. So that leads me to Rahimi. And Rahimi was just decided June 21st of this year. And the court said, no, the right to restrict firearms is a right that the legislature has. And, you know, the Chief Justice Roberts wrote the opinion. His opinion is 18 pages long. The entire opinion is 103 pages because several of the justices wrote individual concurrences, and one justice, Justice Thomas, wrote a dissent. What's interesting about Rahimi is it was a Texas case, and Texas had a statute that you could not own or possess a firearm if you were subject to a restraining order. Same statute also in the federal structure. And Rahimi was also linked, by the way, to 5 other shootings and 1 other domestic violence matter besides the one that brought this case to the Supreme Court, which to me really shows the danger of firearms, of those who have been restricted by a restraining order to have firearms in their possession. And the court says, when an individual has been found by a court to pose a credible threat to the safety of another, that individual may be temporarily disarmed, consistent with the Second Amendment. So the next case we have is Bailey v. Murray. And Bailey v. Murray, I talked about before. I'm going to talk about it in my next presentation again with regard to how you can plead things in a restraining order. But there was also the issue of a firearm in this case. So in this case, there was a dating relationship between the parties, and the court issues a restraining order based on Murray's allegations that Bailey sexually assaulted her. And the trial court considered the possession of the firearm in violation of a restraining order in making its order. So what happened here is Bailey gets the temporary restraining order, and Murray is believed to have had a firearm, a Smith & Wesson. It comes up in the Klutz report, which the court always gets. And when the court gets the report, it says, oh, you have to surrender your firearm. His attorney submitted a declaration, it's called the DV 800, saying that he had turned in the firearm, but it was incomplete. And the court said, well, I'm going to give you another day to complete this. Otherwise, I'm going to find you in violation of the restraining order. And the attorney says, well, you're going to have to report him to the DA or whatever you have to do. My client pleads the fifth and is not really going to complete the form. And so when the court makes the order for the restraining order, it says you violated the restraining order by possessing a firearm. I said I was going to find you in violation if you didn't prove to me that you had relinquished the firearm, and you didn't, because you didn't complete the form fully. So I don't know if you relinquished the firearm. Interestingly, after the court made the order, Murray then blurts out, I never had the gun, but it's a little too little and a little too late. But what is interesting about this case, what I mentioned before, is just the mere fact of owning a firearm and that being a violation of the restraining order is enough to qualify for abuse. 6203 specifically provides that engaging in behavior that has been enjoined, the court can consider that as abuse for purposes of the DVPA. And I'm going to run a little bit over, but bear with me. So the next case is about the type of relationship. So what type of relationship do you have to have in a domestic violence matter? Now, this case, MAV-BF, it's a tort case. So MA sued BF for monetary damages for domestic violence. They met in college. They saw each other sporadically over 19 months and really just to have sex. MA testifies that they texted and saw each other occasionally, but she testifies they did have an 11-month hiatus. And each time they met privately, and it was understood by both that they would have sex. And the trial court says she did not prove the requisite dating relationship. What had happened, by the way, is the basis for the domestic violence is the last time that they were going off for a rendezvous, he pulls her hair in the car and says something like, do you like it when I'm rough? And then whips her head around by her hair. And she suffers a concussion. At the trial, there was testimony from MA's therapist that she referred to BF as friends with benefits. She says it's very clear BF was not a BF. And the Court of Appeal says that the interactions between the two of them were not frequent, intimate associations, which is how the family code, even though this is a tort case, we looked at the family code to decide what is a dating relationship within the plain meaning of those terms. And it's the dissent, I think, brings out an excellent point in it talks about, well, are we old-fashioned in our idea of what a dating relationship is? What about intimate relationships via social media? Those happen. So if you had a sexting relationship with someone, is that frequent intimate associations? So this case, in my mind, kind of muddies the waters more than makes them clear. But again, the totality of the circumstances in this case, especially when even MA's therapist is saying, she just said friends with benefits. She also had sex with someone else, didn't consider it cheating because she didn't consider him really her boyfriend. So I bring this up. It's an important case that came out. Again, it's not in the family law context, but it does affect family law. And so the real takeaway is that frequent intimate associations is really what defines the dating relationship for purposes of the DVPA. And then finally, we have a custody and visitation case where 2 months after a judgment of dissolution is entered, the wife files for the restraining order. The dissolution had stipulated a very detailed custody and parenting plan that had joint legal and physical custody. They also had to use talking parents. And wife says he began a campaign of harassment via talking parent messages. He's showing up at the child's extracurricular activities on my time. Basically, he's harassing me and disturbing the peace. She requests all the standard restraining orders, does not list the minor child as a protected party, doesn't ask for a change to custody, and she doesn't address custody in her declaration or her MPA. The hearing, the court issues a 1-year restraining order, and sua sponte on its own modifies custody to sole legal, sole physical based on 3044. And the court says, no, you can't do that. You cannot bring up 3044 if it wasn't brought up by the parties. And it wasn't brought up by the parties because nobody sought a modification of custody. And it's the plain language of 3044 that says the presumption arises upon a finding that a party seeking custody of a child has perpetrated domestic violence. Nobody was seeking custody. They already had custody orders. Didn't preclude the parties from filing a separate RFO on this, but it was error for the court to, on its own, say, I'm going to modify custody. So thank you for bearing with me. I know I ran a little bit over, and I look forward to seeing you all. Well, I won't really see you at the next presentation that I do.